And our last case of today is People versus Clinton. Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and you have time that you may reserve for rebuttal, but we ask that you keep track of your own time, and you may begin when you're ready.
All right. Good afternoon, and may it please the court. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Clinton. I'll waive any free fire period I have and accept the court's questions at any
So,
time.
counsel, I'm just going to ask the easy question that kind of goes to the basis of it. Why is this not just a civil matter?
I think it is fairly simple. There's multiple ways it could be resolved that maybe, but I think this falls straight forward under its this court's existing precedent under Christensen. It seems like a one-to-one scenario to me that that's the controlling case. So I do think it's fairly simple. I think, what we're asking the court to do here is to adopt a rule that when there's a down payment made to a contractor for a construction contract, that it's not held as property of another. That's consistent with Christensen, as I had just mentioned, but it's also the majority of position adopted by other states here when addressing the same circumstance. I think importantly, it also addresses the realities of these types of contracts, that they're inevitably problems that lead to some form of litigation, that there are delays, damages to property, changes in the scopes of construction contracts, and any number of issues that come up that are very common during these circumstances. I think it's also important to make clear that this doesn't mean that people that are in the position of maybe being wronged when by a contractor are without recourse, and that the state is potentially not without recourse. I think when looking at this, there's of course civil remedies that a plaintiff could pursue based on civil contract.
Is there any situation where there could be conversion then under your argument?
I believe that no. I think that the issue is where the criminal law can come into place is the circumstance contemplated by Christensen, which is a charge of false pretenses.
So never conversion?
Not conversion, no. When there's in these circumstances involving a contractor, so someone distinguishable from the other case cited by this court's opinion, the Mason case or Franz or O'Shea, those all deal with a very simple one-to-one transaction. I'm giving you money either in the form of a down payment or a complete payment for a completed good or a piece of property that I'm giving you. That's distinct completely from these types of cases where the contractors are involved. That inevitably involves a more complex situation, involves labor, materials, and things being used to make these kind of things. And in light of those circumstances, the majority of courts have, and I think Christensen is in line with this position, but maybe just not as clearly as.
So counsel, is there like a line, I mean, is it just job has started or not, that's it? I just had new bookshelves built at my house. So contractor comes, he measures, I give him a deposit, and I never see him again. So under that, can I go to the police and file a report and he gets prosecuted?
I think the answer is yes, but not for larceny by conversion, right? That would be a circumstance where arguably there could be a charge of potentially false pretenses under Christensen, right? That's something where at the outset, the individual, there could be potentially a factual basis to say they never intended to do what they came to the house to give you this estimate for.
Let's say that they did. So let's say you have all 7 of us are putting in swimming pools at our houses, and Justice Thomas starts it off, and she's like, I've got this great contractor. He's not done. He's 50% of the way done, but it's great. Like this is great. And she refers every single one of us. And so just down the line, and they go and they take a deposit from each of us and then get started. But whatever happens, and they can't complete any of the projects.
I think that the answer.
How is that false pretenses?
Well, I think that it's not, right? But it's also not larceny by conversion, but that individual who's
Even if they get halfway, like, they get to me, and no work is being done, and then they're intending to do it, and then they're just taking more and more money, never conversion.
Never. Under this rule, no. And I think Christensen makes that clear. That was the situation where the individuals was contracted to build several homes, had begun the project, and then they've had experienced financial difficulties, went into bankruptcy, and then used the funds that were given them to do this project to pay off other debtors, and also did not complete the work. And Christensen made clear that that still, under those circumstances, does not justify a charge of larceny by conversion. So I think it's clear that it's just not the appropriate charge. In some cases, there may be a criminal action that could take place, but it would be under false pretenses. And that's the majority rule. Even in the minority of cases, which the Galbraith case mentioned in State versus Joy, that deals with cases where there's a contractor that's engaged for something that's highly earmarked to say this is only for this. And I just want to make clear, the prosecutor's argument seems to be at least premised in part that this contract between the complainant and Mr. Clinton was solely for the purpose of purposing equipment. That's not only factually incorrect based on the testimony, it's inconsistent with the trial court's findings of fact in its opinion deciding the issue of guilt here. It was very clear that the court found in its March 17, 2022 hearing that this was for purchasing the equipment and actually doing the physical work of installing the equipment.
So, Counselor, if there were a contract that said for these bookshelves, the first $200 is just to buy wood, and then everything else after that is the making of the bookshelves, and there's $200 given over, and the wood is never bought, that good would potentially be a larceny by conversion, but here you have mixed goods and services, or the contract to do the work.
Yes.
That makes this different, is that right?
Yeah, and that makes it, and to be clear, that makes it only different from the minority position, right? The majority rule, so that's the State versus Joy, the Washington Supreme Court's formulation of it. Under the majority approach, which is adopted by every state that I could identify to address the issue besides Pennsylvania and Washington, that this is, if it involves a contract by a contractor with a property owner, that whatever down payment gain is not considered property of another, and it's not a viable charge for larceny by conversion. I also wanted to make clear that if the court didn't feel the need to expand upon what already is stated in Christensen, because I do believe we prevail under that rule, I think it's maybe not necessary to go to the point to say that all contractor cases fall within this category. But I think here, as I had mentioned, this case falls into the circumstances directly contemplated by Christensen. It is that issue, and it should have been treated that way from the outset. I mentioned the issue with distinguishing this case from the other cases. This wasn't a contract for specific good. It just is not an applicable thing. Regarding the second question, I think it's important to know, outside of the case being distinguished from the Mason line of cases, this is a circumstances where work was performed, albeit not to the complainant's satisfaction. There was some, a sewage line damaged, there was work started, and it just wasn't going at the pace and speed the complainant would have liked, and this led to the conflict which caused them kind of the fall apart of the relationship there that led to these charges. And I think it's just fundamentally different from the circumstance where you can infer that someone had the intent at the time to deprive them of property. So unless the court has any questions at this moment, I would reserve the rest of my time for rebuttal.
Thanks.
Okay.
Good afternoon. May it please the court, Emil Sama on behalf of the people. I was at the very beginning of this panel, and I'll be at the
You're
very
busy
end.
today.
Third time.
Like, you're here a lot.
I feel like we owe you an apology for scheduling you for 3 cases in one
He
day.
Well,
asked.
Oh.
I did. I did.
You wanted them all
I'd
in
rather
one
just
day.
do it
Then you
all
get
in one
what you
day
get.
and be done
Yeah.
with it. It was just much easier to get it done in one day. It's
No
like
apology.
a Band-Aid, rip it off. I think I want to kind of address the question, why isn't this a civil matter? And to use the argument of a broad rule of whether all contractor cases can never be largely by conversion. I think that's too broad of a rule to make in any kind of situation, because you have a continuum. I mean, I've prosecuted, as a trial prosecutor, largely by conversion, where they've said, I'll do all this work, I'll get you all these things, took all the money, and was never seen or heard again.
But
Right.
isn't that different than here?
I'm sorry?
That's different than here. isn't
Yes,
it?
yes. But that's why I'm arguing against a broad rule. Broad rule saying all contractor cases can never be largely by conversion, I think just paints too wide of a brush that doesn't take into account all the different factual scenarios where largely by conversion would be applicable in that situation, versus ones where they did start to do work, they were providing services, they were doing it incrementally, and then situations beyond their control, as you see in civil matters, the level of impossibility or whatnot, have hampered the construction project. I think this falls in the middle, where we are here, back.
What about the line between if you're contracting for a completed good, as Justice Thomas said, or a product versus a completed good in product and services, or use of that? Is that a good distinction?
No, I think
That
services
if I'm
can
gonna
also-
give you $200 worth of wood, or air conditioner, A, B, and C, and if I don't do that, that might be larceny by conversion, but if it's providing services, you're out, it takes you out of that realm.
I don't think it would take you out of the realm, and here's why I would say that. If, in that hypothetical, you only gave him the $200 to start with, and he never did anything with the $200. If you give him $7,000, for example, $200 for the wood, and the rest to build the bookshelves, and he still did nothing, I would find it hard to argue that we can only go largely by conversion for the $200, but not the rest of the $7,000, because it all seems to be part and parcel entrenched in the situation. And this, you have a mixed services product contract situation going on here. Buy the HVAC system, buy the register lines, buy all this stuff, and install them, right? It wasn't just a services contract, nor was it just a products contract. It was buy all this product and put it in, and he did none of that. He didn't buy any of the products except for a few minor things, and the only work he did ended up causing damage. I think when the
Right,
court-
but isn't that a civil matter? Like the damage, I agree, it sounds like this project went awry. Isn't that what our civil system is for? I have to tell you, my past life involved a lot of contractors in my job. And trust me, like there were times we like tried to get law enforcement involved on things and we couldn't because we were just always told it's a civil matter. So, I mean, if it's just like, that to me sounds like that's about a monetary dispute if there was damage.
Yes and no, because at some point, you're right, but some of the work that was done, that could be done, would make it into a civil dispute. But when you have somebody who comes there, who just sits there all day, the person themselves, Mr. Clinton, never appeared in those days. It was his cousin Tom, who just sat there and just watched and did nothing. And the one time he finally did work when he was called out, he broke something and still never delivered the products he had. The only HVAC system that was brought was a personal one to keep the employer or the employee cool while he's doing the work of which no work was done. So it's one thing to say that you may have situations that affect the construction that happens here, but here, I think when the court was looking at it and when the court was making its decisions, looking at all the different exhibits and all the testimony that it heard firsthand, it found that this went beyond just a normal contractor dispute, and that's our position. Of course, if this court disagrees, this court, of course, can disagree, but I would absolutely disagree with finding a broad rule that any construction contract can never be largely by conversion.
What is the evidence that he converted the money for his own purposes? Is it enough to show that he didn't use it for the equipment and services that were in the estimate, or is that sufficient to say that he converted it for his own purposes? Like the case, and I'm blanking on it now, where you say, you used it to pay off, the bankruptcy or the debt or what have you,
I think that was-
where you knew where the money went, right?
Yeah.
Like, do you need to show that for converting it, like,
Where
for
I
use?
think it would be enough to show the fact that none of the services or products were provided, or at least practically none were provided, and it was never refunded. There was no refund given, there was no HVAC system and full lines developed, and no actual installation of anything that was done here. And yet no money was refunded and nothing, and then he brought in exhibits to show, well, the amount was greater than I went, but those were impeached by the prosecutor's exhibit. So it came down to a question
So
of.
that sounds like a pretty broad approach on the other end, where.
Right, it just as long as it wasn't used, it wasn't used to provide the things that were contracted for, therefore that means it was used for his own use.
I think it would be if it was, I think that's what Mason would have gone into. With Mason, it was if you were specifically contracted to use it for a specific thing and it wasn't used for that thing. Whereas Christensen, you had progress payments, things were going on. I think that was the distinguishing factor between those two, at least, in that regard. So with Mason, you had it was specific to these products and services. Those were not delivered, and no refund was given. That was as far as Mason went, if I remember correctly. And I could be incorrect, and I apologize if I am. But I think that, I'm not asking for too broad of a brush. I mean, I guess we could subpoena defendant's records and find out if he's using it to go gambling and go partying and jet-setting lifestyle, or if he's using it for other projects in a kind of giant Ponzi scheme and not using it for the work that he's supposed to do.
Well, I mean, a Ponzi scheme is, I think, maybe one step further. I mean, there could be good intent, right, where it's like, I'm trying to cash flow, and I've got to complete this, and, you know, I'm maybe using this money to then, you know, and they're putting it all together. So I think the facts matter in that situation. I think what Justice Kavanaugh is asking, and what I'm curious about is where that line is, because you can't, you know, as you said, saying that, you know, no conversion, larceny by conversion can apply to these cases is too broad. I think it's too broad to say, as long as the money is not refunded and you didn't do any of the work or provide the goods, that can be larceny by conversion. I feel like that's very broad the other way. So there has to be a line and I thought that it was, what do they do instead, and is it for their own use?
And I guess that is a question, I guess if it's one rule that can be answered, but I think the issue with that goes to the intent of the defendant with regard, I think you said even in your question, was the intent. And there is a minimum amount of requirement for us to show intent. A lot of times it's by circumstantial evidence. And the fact that circumstantially he didn't provide any, if a defendant in general doesn't provide any services, produce any goods, and does no work, and does not provide a refund, the only the circumstantial inference is that he intended to convert to his own use. Now that could be potentially rebutted, but
Okay.
I think for the purpose
So
of
if the money is sitting in the bank,
yes, if the
money's
money's
sitting in the bank, and he's like, listen, there's issues getting supplies. I haven't bought it because I'm waiting for these supplies to come in, and the money's sitting in the bank, then that's rebutted.
I think that for the factual determinations and individual cases will come into play.
So are you arguing that, the money should be segmented somehow? Like, almost like lawyers with our IOLTA accounts? Is that what a contractor's supposed to do? I would imagine most contractors take the money deposited, it's just commingled in their general checking account.
Wouldn't that be nice, though, if we had IOLTAs for builders and contractors? I think that would make a lot of us happy in some situations. But no, but I think it depends on the language of the agreement and the contract that was involved here for the larceny by conversion. And I think you saw that with the Mason and Christensen, because in Christensen, it was just to do progress of modular homes in different stages, and they were doing it to that work. Mason, when they did a specific requirement that the money was for a specific thing, a specific product, a specific installation, and it was not done, that's where you got into a difference. So I'm not so much worried about the commingling of funds situation. I'm more worried about the fact that if they don't do any work, they don't provide any materials, and they don't offer a refund, I think circumstantially we've shown the intent that they were not going to do it, and they've converted the funds to their own use.
So are you also, though, in order for your position to win in this particular case, are you also asking us to find some sort of de minimis performance? Like, because as you even admit, like, it's not that nothing was done, right? Now, you may say that it wasn't enough, that it was somebody else instead of this guy, and it was an air conditioner for either keeping them cool or tempering the building or whatever you want to say it might have been for. There was something done, and you're saying it was so de minimis that we should count it as if nothing was done.
I think that's what the court found. I think that when you look at the de minimis goes to the intent, because minimal evidence, even minimal circumstantial evidence, is used to help establish intent. That has been case law in almost every criminal code we have when it comes to intent, because it's hard to read people's minds. We just never can. So we base it upon their actions. So I think whether or not the court and the arguments by the people at the trial court level was that this de minimis amount was enough minimal evidence to show that his intent was to convert and to defraud. And I think that's what I'm asking the court to look at when you look at all the evidence and circumstances together. Right? I'm not asking you to hold a bright line rule that if they do this much but not this much, then we're in conversion versus other. I think it's always going to be a case-by-case factual situation.
And what is your evidence on the deposit itself, what the purpose was? So I've got the estimate in front of me, and we've got these products lined up, but then we also have a note about installing the furnace.
I think that the estimate was that money was for the products and the installation. That was what the estimate showed. That you will purchase these products and install them, right? Buy me a garbage disposal and put it in the sink. Is basically what the estimate appeared to read. And I think that's the contract they had, and that was the agreement they had for the specific monies they did.
So it was for both things?
Yes.
Okay. Does it matter that the defendant here did not abscond? This is not like a lot of the cases we've heard about or the examples we've given where somebody just doesn't show up. He did show up, and obviously the parties decided to part ways. So does that matter?
I think it can matter both ways, right? When a defendant absconds, we obviously would use that as part of our argument. The fact that a defendant doesn't abscond is an argument to show that he didn't have the intent. Again, though, but that's a question that's going to come to the trier of fact to determine whether or not. So I don't think just saying that they did or didn't abscond proves it one way or the other. I think it's just one other factor that you consider when looking at the totality of the evidence to determine whether or not you have a guilty or reasonable doubt.
Yeah, how do you prove an intent to take money if you were still willing to continue working on the project? I'm just questioning how that can be.
Well, I mean, it's one thing to say that I'm willing to work on the project, but also return with text message saying now it's going to cost this much, and it's going to be this much, and it's going to be this much. Now you're saying I'm going to come back, but not till you pay me. Now there's an extortion part to that. Sure, I'll come back and do everything, but now I need another $10,000, please.
Isn't that like just about every construction contract? I mean, I'm not trying to be glib, but I mean,
No.
and this is the nature of why we can debate whether or not that work is needed, or that's how much it should cost, or how much we should do all this. We typically debate that in the civil context of damages, right?
In civil context, yes. And I think that there's some situations, but I don't think that I disagree with the idea that a contract case can never be largely by conversion. I know that there are some facts that will differ with that. And you're right, sometimes they go up. But I've seen cases as well where the person has done no work, has done nothing, and keeps asking for more money, and threatening to withdraw stuff or hold stuff. And those have been largely by conversion because they've done nothing. Whether this case, I think, again, falls somewhere in the middle between the full contract case where they're doing some stuff and they argue impossibility versus the one who's done absolutely nothing and has provided nothing and yet keeps demanding more money as some kind of extortion scheme. I think this one falls in the middle, and whether or not it qualifies, again, will be what this panel of justices will determine. If there are no further questions, I ask that you adopt the rest of my brief.
Thank you.
Thank you.
He knows the drill.
For you, my friend.
I think I wanted to address the concerns about this rule being too broad. I think, as I mentioned, this is the majority of rule adopted by states when it comes to the crime of larceny by conversion. And I think one of the concerns potential in these cases, if it is someone that at the outset says, yeah, I'll do this, shows up to the house, gives you an estimate, and takes a huge down payment and just ghosts, essentially, the person, that there is a crime for that. It's just not larceny by conversion, and it's false pretenses. When looking at, the conversion issue, I think, the trial court's decision here did not consider Christensen at all. It focused solely on these other cases where there was a completed good or product that was being purchased. Again, that's fundamentally distinguishable from the situation addressed in Christensen, which dealt with the creation of homes, which is not much different than doing heating and cooling work. I can say it's someone who my parents owned a heating and cooling business for decades. I worked for them throughout high school and college, and the type of work you could do it varies depending on the type of job, and some jobs are more involved than others, and it's not simply delivering a furnace to someone's house. There's a lot more labor and materials that go on both at the job site and behind the scenes that make these cases different. I do think that, they're important to look at in Christian. There is a reference to a trust, right? That the funds in Christensen were not held in trust, so that when the contractor in Christensen received the down payment to construct these modular homes, he was free to use that money how he saw fit. Unfortunately, in that circumstance, he did go bankrupt and then used that money to pay off debts, as opposed to it just maybe merely going into a general fund. But even here, looking just at Christensen on all fours, this is a straightforward application of Christensen. If the court feels that the rule I'm advocating for here that's adopted by other states may be too broad in Christensen, just as in Christensen, there was no agreement to a trust. We just have simply here a verbal contract to purchase and install heating and cooling equipment at the home. And a dispute ultimately ended between the complainant and the contractor, Mr. Clinton in this case, led to the dissolution of that contract and the issue we're having here. And that's something, under these circumstances, there's one way to address that, and that is civil court and not criminal court. So unless the court has any other questions, we'd ask this court vacate Mr. Clinton's conviction.
Okay, thank you. Thank you both. The case will be submitted, and the court will be in recess until tomorrow morning at 10:10.